After the hearing in the Blake Lively versus Justin Baldoni and Wayfair case, there hasn't been much going on there, and that's because they're waiting for the judge to rule on the Wayfair party's motion for judgment on the pleadings and motion for summary judgment. There were also some arguments there made about the spoliation sanctions motion by Lively. Lively has filed a host of sanctions motions in this case. Most of them have not been ruled on yet. But I was able to go to court that day and sit there and listen to them argue back and forth about it, which was interesting. I had never been to federal court before, but I knew it would be a while after that, probably before the judge made a decision on those things. Trial is set to start on May 18th as it stands. And that's just for Blake Lively and the Wayfair parties. The side action, the adjacent case between Stephanie Jones and the Jennifer Abel and the Wayfair parties, that's they don't even have a trial date for that yet. So things have been kind of hanging in suspension, I guess, until the judge, rules on these motions. There have been a couple things to come out on the docket, but it's mostly just requests for these pre-trial motions for the deadline to be pushed back. So I didn't really think that was anything like super substantial. However, they did get a little bit of an extension at least. And then I know they asked again for that to be pushed back. The Wayfair parties were wanting a certain amount of time to be set like within the judge's decision on the summary judgment motions. Blake Lively did not agree to that, but they had another date in mind that they did agree upon. So sorry, I had to pull that up and try to remember exactly what he decided on. I guess he did give them, he decided to extend the deadline by a week again, but he did not want to do the 21-day thing that the Wayfair parties were asking for. So they have less than a month to submit these pretrial filings. So I hadn't really brought that up here because, to be honest, I didn't really think it was anything to write home about. It just didn't seem like that interesting. I'm not surprised they asked for an extension given that, the summary judgment motions still haven't been ruled on. But this afternoon, Blake Lively submitted another request, and Lively's attorneys are informing the judge about this brand new appellate ruling that they think will help them win their argument procedurally. They're not writing a motion to the court, but they wrote him a letter asking for him to take notice of a supplemental authority. It's really short, so I'll read it here, and then I'll try to, I'm not a lawyer, but I think I can put it into like plain English, hopefully. It says, "Dear Judge Liman, Plaintiff Blake Lively respectfully submits this letter to provide notice of the Second Circuit's recent decision in Miller v. Lamanna, which compels the denial of defendant's motion for judgment on the pleadings. In Miller, the Second Circuit held that the district court had committed procedural error and abused its discretion when, after discovery and at the summary judgment stage, it dismissed the plaintiff's claims by applying the Rule 12b6 standard to the plaintiff's operative complaint rather than reviewing the evidence adduced in the summary judgment record. And as the Second Circuit elaborated, even if the allegations in the complaint were insufficiently detailed to survive a motion to dismiss, had such a motion been made before discovery, if the evidence collected in discovery raised triable issues of fact, it would have been appropriate for the plaintiff to amend his complaint to conform to the evidence thus collected. Dismissing the complaint at that stage, when the evidence adduced in discovery may have been sufficient to survive a summary judgment motion, would hardly serve the efficient or just resolution of disputes, which is the very foundation of the federal rules. The law does not evince over concern, especially at later stages of a case, with reverting to the original pleadings when the actual evidence is sufficient to establish a claim or defense later on." So the motion for judgment on the pleadings, if you don't remember, is a little different from the motions for summary judgment. And this is in the most basic explanation possible, because you guys know I'm not an attorney. There are plenty of attorneys who have been out there to explain this kind of stuff in greater detail. But just as a reminder, the motion for judgment on the pleadings is basically saying that even if everything in the complaint, the lawsuit, is true, the plaintiff would still, the Blake Lively would still lose as a matter of law. Okay, let me just read the second paragraph here, and then we'll talk a little more about that. As Ms. Lively explained in her opposition to defendant's motion for judgment on the pleadings, the second amended complaint alleges more than enough facts to survive defendant's motion. But as Ms. Lively also argued, the motion for judgment on the pleadings is directed at the wrong question, because at this stage of the case, Ms. Lively's claims must be evaluated based on the evidence amassed in the summary judgment record. Miller thus confirms that defendant's motion for judgment on the pleadings must be denied, that it would be appropriate to deem the complaint amended to conform to the summary judgment evidence, and that Ms. Lively's claims must be assessed on the basis of that evidence. And I pulled up this case she's citing. The decision came down 3 days ago. It says, after 2 years of discovery, defendant appellees moved for summary judgment. In their motion, in addition to arguing that the entire record failed to demonstrate the existence of material issues of fact about Miller's constitutional claims, defendants also argued that Miller's complaint should be dismissed for failure to state a claim. The district court disregarded the parties' factual arguments based on the summary judgment record and dismissed Miller's claims under Rule 12b6 after having considered only the allegations in the complaint. They're saying the judge here dismissed Miller's claims after having considered only the allegations in the complaint. But with the type of motion in this case, the judge was supposed to look at the evidence, I think, not just the complaint. So the judge made a mistake in not considering the evidence, and then the ruling was vacated. So basically, 2 years of evidence had been gathered, and the judge made an opinion by deciding the case while pretending that the case was still at the complaint stage and the evidence didn't exist. That's a pretty different scenario. Not only that, but I think this motion for summary judgment that they're in the case that they're citing here, it's not the same as the motion for judgment on the pleadings in the Baldoni case. It seems like this is saying the court cannot treat a summary judgment motion like a Rule 12b6 motion and ignore the evidentiary record after discovery has been completed. But we're talking about a 12c motion for judgment on the pleadings in Justin Baldoni's case. So I'm not sure that makes sense. And again, I'm not an attorney, so maybe there's some stuff here that I'm just missing, but this doesn't totally make sense to me. I feel like there could be some pushback here. Their Rule 12c motion for judgment on the pleadings is actually designed to, give a judgment based only on the pleadings. Like the complaint, the Wayfarer's answer to Blake Lively's complaint, and the documents that are within those things. It's not the same as the motion for summary judgment where Judge Liman would consider all of the stuff that's come up in discovery. So if Judge Liman ruled against Blake Lively and threw out basically her claims, ruled in favor of the defendants based on the motion for summary judgment, but in doing so, he did not consider any of the evidence that came up in discovery, I feel like that would be the same as the scenario that they're presenting here in the case they cited in this letter. But the 12c motion for judgment on the pleadings is asking Judge Liman to assess the legal defects of Lively's pleadings. It's not about evidence. For example, they make that extraterritoriality argument, or they're saying Lively didn't exhaust certain administrative remedies. They're saying Lively's, she shouldn't be able to apply California employment statutes outside of California. None of that really has much to do with the discovery. Or, for example, saying that the allegedly defamatory statements are legally protected. That's a purely legal issue. It would not matter what was said. It would matter whether or not it was, legally protected or privileged for them to say it. I don't know. Hopefully that makes sense. I just feel like that case that they cited there, you can find it on Court Listener if you want to read the decision, but the case they cited there, it's not exactly the same as the scenario we're looking at here. But I'm interested to see if, just because I'm not an attorney, maybe I'm just looking at it the wrong way. So if any of you guys have any other opinions on it, let me know what you think in the comments. Like I said, this wasn't a motion. It was just a letter they wrote to the judge asking him to consider this. So I don't know if the other parties will respond in any way or not. I would think so, but I'm not sure what the procedure is for that. All right, that was a short one, but that's all I got for now. Thanks, everyone. Don't forget to hit the like button for me because that helps me out a lot, and hit the hype if you can. I will see you guys soon. Bye.